Good morning, everyone. I'm Joe Weiler. I'm a professor emeritus at the Peter A. Allard School of Law at the University of British Columbia. And I serve as co-director of the Anti-Corruption Law Program with my friend and colleague, John Ritchie. The Anti-Corruption Law Program is a working partnership of three entities, each of which has different core competencies, but we've pooled our resources together to create and to operate the program. The first of our partners is the Center for Business Law at the Allard School of Law. The second is Transparency International Canada chapter. And third is the recently established Vancouver Anti-Corruption Institute, which functions under the management of the International Centre for Criminal Law Reform, ICLR, which is also headquartered at Allard Hall at UBC. So at this point, I'd like to acknowledge and thank Dr. Carol Liao, who's the director of the Center for Business Law, for her ongoing support for our program, as well as her skilled technical team at the CBL, led by Dr. Lachlan de Jong, with the able assistance of Justin Chuor and Stephanie Lee. These seminars simply would not be possible without that team's very able technical support. They handle and manage their registrations and do all the back office work that's required to successfully stage these webinars. So I'd also like to thank our colleagues at the Anti-Corruption Law Program Partnership, James Cohen, who's the Executive Director of Transparency International Canada, and Susan Cote-Freeman, who's the Chair of TI Canada, Dr. Peter German, President of ICLR, who chairs the Advisory Committee of the Vancouver Anti-Corruption Institute. So these people have made very valuable contributions to the conceptualization of this event, its organization, recruitment of our panelists, and event promotion to make this a success. And finally, I'd like to thank my friend and colleague, Norm Baldwin. Norm is the other member of the senior management team of our program, along with John Ritchie and myself. And Norm's made so many contributions to this series as a moderator of the session number one, recruiter and trainer of panelists and moderators, and just about everything else from behind the scenes that this kind of event needs to go smoothly. So thank you, Norm. So the Anti-Corruption Law Program was established in 2016 as a form of collective action among the three foundational partners and the community that's now been developed around the program. And it allows interesting professionals, business people, consultants, law enforcement folks, government personnel, academics, researchers to share their ideas and in general to raise awareness and educate each other about the law of anti-corruption and best practices in anti-corruption compliance. We began in 2016 with a series of in-person professional education seminars, and then we went to conferences, and these were held in boardrooms and conference centers in downtown Vancouver, where the space was donated by law firms or businesses who then became patrons who wanted to host these events because they wanted to give support to this kind of ongoing top-level professional education around anti-corruption. So in the next few years, we held 20 seminars and conferences and colloquia until late 2019, and then of course, the COVID-19 pandemic forced us to go online, and that actually, has really been a boost for our program with that kind of delivery model. It's been very well received. The webinar format allows us to reach distant audiences and attract distant panelists. And so we've now got a faithful following of hundreds of registrants in North America, Europe, and some in Africa and South America, as far away as Australia. And thanks to the resources of the Center for Business Law, we also are able to archive these webinars. And so people who can't join us live are able to get to that content and get it at their leisure and learn that way. So today's seminar is our webinar is the 15th since we started doing that in 2020. And so that makes 35 events that we've done since our inception 6 years ago. So, and today's seminar is the fourth of a series that we where we looked at the recommendations of the Commission of Inquiry into Money Laundering in British Columbia. We'll call the Cullen Commission. And this is served as, and it was designed as a bit of a mini course so that one session leads to another. And you can then get a handle on the huge amount of material that actually was gathered by the commission. It heard from 199 individuals and organizations, many reports and submissions from interested parties. So there's a huge compendium now of research. And hopefully this is going to be a watershed moment as Canada comes to grips with what to do about money laundering. This first webinar we had in September, and that was focused on private sector, on the recommendations with respect to private sector self-regulation in British Columbia to deal with money laundering. The second in October was organized by TI Canada, James Cohen and his team, and the focus there was on beneficial ownership transparency in Canada. The third was in November and organized by Peter German and his team at the VACI, and that was on unexplained wealth orders and civil forfeiture and how these legal tools might be implemented here in BC. And today is the fourth and final webinar of this series, and today's focus is on institutional reforms within the government of British Columbia, the first being the Anti-Money Laundering Commissioner, and the second proposal for a dedicated intelligence and investigative unit. We've got a stellar panel of experts, as you'll see, all of whom are ready to talk about these proposed institutional measures and ways that they may strengthen the capacity of the government of BC to combat money laundering. So I want to thank in advance the members of our panel for the time and the effort that I know that they've put in to join us today and share their ideas about the viability of these proposals that came out of the Commission. It's my pleasure now to introduce Eileen Patel. She will be our moderator for our panel. Eileen was Associate Commission Counsel for the Cullen Commission. She currently practices civil litigation as a freelance lawyer under the banner of Patel Advocacy, with a focus on commercial and administrative law. Eileen graduated from Peter A. Allard School of Law, and I might add she was the gold medalist in her class in 2010. And following her graduation, she clerked at the BC Court of Appeal and then the Supreme Court of Canada before entering legal practice. So Eileen, thank you for taking on this important role as moderator of our distinguished panel. And now it's over to you. Thank you.
Thank you so much, Joe. It's a pleasure to be here and to be leading this panel of very eminent scholars and practitioners in the AML area. I'd like to, as Joe mentioned, the anti-corruption law program is connected with the University of British Columbia. And so I'd like to begin by acknowledging with gratitude that UBC's campuses in Vancouver are situated on the traditional unceded territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. And UBC's Kelowna campus is on the territory of the Syilx Okanagan Nation. I'm going to start by just giving everybody a bit of an overview of the topics that we'll be covering today. And I'm also going to address how attendees can send questions to myself and to the panelists, which I encourage you to please do. We're looking at, as Joe said, principally two recommendations that the Commission made directed to the province of British Columbia. The first is the creation of an entity called the the AML, anti-money laundering commissioner, which is recommendation number 1, actually, of the Cullen Commission. And the second recommendation we're looking at is for the recommendation for the creation of a dedicated provincial investigative unit targeting money laundering. And just for reference, if anybody's read the report or has it handy, or wants to look at those up later, and we will be looking at the actual text of the recommendations just to ground us a bit, but those are recommendations 1, 91, 94, and 95, and we might mention some other surrounding recommendations as the discussion progresses. The general purpose, we've determined that what would be useful in this discussion is first to establish what the recommendations are, try to get a sense of why they were made or what gaps they're intended or systemic issues they're intended to address. And then we'll be drawing on the extensive expertise of our panelists today to get their views on where they think that these recommendations hit the mark, where they fall short, what potentials they see for these 2 institutions that the Commission recommended the creation of, and what difficulties they see in the future for their success. We'll also be giving the panelists an opportunity to speak to any other recommendations directed to the provincial government that they particularly want to have a word on. So there will be an opportunity there to get outside the framework of those 2 institutions we principally wanted to discuss today. For questions, you'll see in the bottom of your screen, well, it's the bottom of my screen. I'm assuming it's the same place for attendees. There's a Q&A box with a couple little speech bubbles. Please, if you have questions, please write your questions in the Q&A box. Both I and Justin, and I think Stephanie, are going to be monitoring that as we go ahead. Please, if your question is directed to a particular panelist, you can indicate there that the question is directed to that person. Don't try to, I don't know if it's enabled actually, but please don't try to chat directly to the panelist. Just write it in the Q&A box. And towards the end of our discussion that I'm going to be leading with the panelists, we will have about 15 minutes, hopefully, to address questions and have a Q&A with the audience questions. That, I think, covers the technical issues, and I'd like to go ahead and introduce our panelists now. All right, let me see. First, we've got our first panelist is Denis Meunier. Good morning. Denis is a former Deputy Director of the Financial Transactions and Reports Analysis Centre of Canada, FINTRAC, as it's more commonly known, where he was responsible for compliance operations and the production of financial intelligence and disclosures. He is also the former Director General of the Criminal Investigations Directorate at the Canada Revenue Agency, a technical assistance expert with the International Monetary Fund in several countries on capacity building in anti-money laundering and anti-terrorist financing, and he is an instructor at the University of Ottawa. So good morning, Denis, and very happy to have you here.
Good morning, Eileen. Thank you to be here.
Okay. Garry Clement is the Chief Anti-Money Laundering Officer at London, Ontario-based Versabank. He previously spent 34 years, I think that's right, in law enforcement, including being the former National Director of the Proceeds of Crime Program for the RCMP. That's something that we'll hopefully, definitely will circle back to and hear a little bit more about. Working as an investigator there, an undercover operator in some of the highest organized crime levels throughout Canada. He's received numerous awards and commendations for his investigative abilities. He has recognitions from, including from the U.S. Drug Enforcement Administration and the CIA. So again, very happy to have Garry here this morning.
Thank you, Eileen.
Finally, we have also Dr. Christian Luprecht, who is the class of 1965 Distinguished Professor at the Royal Military College of Canada. He is also the director of the Institute of Intergovernmental Relations, School of Policy Studies at Queen's University in Kingston, Ontario. He is an expert in security and defense, political demography, and comparative federalism and multi-level governance. He's held visiting positions in North America, Europe, and Australia, and is regularly called as an expert witness to testify before committees of Parliament. Christian's also the Monk Senior Fellow in Security and Defense at the Macdonald-Laurier Institute. And I should mention, he's also the author of a number of books. Recent titles include Patterns in Border Security, Intelligence as Democratic Statecraft, and Public Security in Federal Polities. And that's just I apologize to all of my panelists for somewhat shortening your biographies, which the full description of which could take us a good portion of this morning's time. So welcome to all of you, and thank you so much for being here to share your expertise.
Thank you.
I'm going to start first with the Commission's recommendation for an anti-money laundering commissioner. And just to ground us and the audience in what that recommendation is, I'll ask Justin now if you could pull up recommendation number 1, if we could screen share that. All right, and we're not assuming that that everybody in the audience has read through the report with a fine-tooth comb and might not have it in recent memory what this precise recommendation is. So we're just going to review it. Recommendation number 1, again, it's the very first recommendation that the commissioner made, was that the province establish an independent office of the legislature focused on anti-money laundering, the Anti-Money Laundering or AML Commissioner. And the responsibilities of the AML Commissioner are anticipated to be producing a publicly available annual report on money laundering risks, activity, and responses, as well as special reports on specific issues. B, undertaking, directing, and supporting research on money laundering issues in order to develop expertise on money laundering issues, including emerging trends and responses informed by an understanding of the measures taken internationally. C, issuing policy advice and recommendations to government, law enforcement, and regulatory bodies concerning money laundering issues. D, monitoring, reviewing, auditing, and reporting on the performance of provincial agencies with an anti-money laundering mandate. And E, leading working groups and cooperative efforts to address money laundering issues. And I think we'll maybe, Justin, I think the next slide has recommendation 2, not directly related to the AML commissioner, but in the context of kind of institutional recommendations directed at the provincial government, it's related. So it might be useful just to look at that now, to have that in mind as we proceed with the discussion. Recommendation 2 is that the province maintain the Deputy Ministers Committee and Anti-Money Laundering Secretariat, which are government entities that have pre-existed the Cullen Commission. They be given responsibility for continued development and implementation of the provincial anti-money laundering strategy, including the implementation of measures identified in this report. And then I think we also have recommendation number 3, if that's right, we can go forward to that. Thank you. That the province introduce a statutory requirement that all government agencies, regulators, and law enforcement bodies with an anti-money laundering mandate designate an anti-money laundering liaison officer to be the primary point of contact for improved interagency collaboration and information sharing. And of course, just some background to that recommendation there is that in various places, the commission report recommends that regulatory bodies be given an anti-money laundering mandate. Okay, so Justin, thank you so much. You can go ahead and take that down now. I think I'm going to start, Denis, if you don't mind, getting your views on the what is the usefulness of this recommendation, and your thoughts on the concept of this type of office, which is kind of more analogous to the information privacy officers, the Office of the Information Privacy Commissioner, not a ministry or an agency, but more in line with those independent offices. So I'd love to hear your thoughts.
Well, thank you, Eileen, and once again, thank you for the opportunity to be on this panel with esteemed colleagues. I think this first recommendation is absolutely critical as part of the backbone of the whole reform that can occur in British Columbia in particular. It is a recommendation that is rooted in the fact that there is a lack of centralization and coordination in the province between regulators, law enforcement, intelligence, the whole broader perspective on what's happening in terms of risks, threats, vulnerabilities, and risks in order to move forward on implementation of policy or policy development, and then implementation and actions that need to be taken overall within the province. I think it's a fantastic and necessary recommendation. It provides a focus for actions to be taken within the province, and accompanied with those two other recommendations that you showed, recommendations 2 and 3. 2 was the question of the AML Deputy Ministers Committee, which is actually there to bring together all of the agencies and actually implement any kind of advice or recommendation that could be made by the AML Commissioner as well. What I like about the concept of AML Commissioner is that it's been recommended to be independent and reporting to the legislature. That is absolutely critical, and you need the right person to demonstrate independence in terms of public interest, to bring confidence to the fact that the AML Commissioner will be focusing on this issue and won't be responding to the vagaries of political masters, but really as an independent person. That recommendation 3 basically was the statutory designation of AML liaison officers in each of the regulated bodies or agencies in the BC government that would have a responsibility for AML, an AML mandate. And I can count at least about 6 that the Commissioner has mentioned, but perhaps even more could be brought into this. And it's particularly important that these 3 recommendations, in my view, be looked at as a package, as a backbone to really strengthen the focus of threats, vulnerabilities, and risks, as well as making recommendations for taking action within government departments, and also with respect to those regulators, 6 or more in the province, that have an AML mandate, in order to statutorily recommend a point person, a focal point that the Commissioner can deal with, and that can be collectively sharing information about what's happening and what should be done in the province. So I would like to maybe one more comment in that to add to your in response to your question, and that has to do with the fact that in Canada, we're supposed to be doing national risk assessments on money laundering and terrorist financing. The last one came out in 2015. So we're kind of late on production in this point. But this is where the AML Commissioner in the province could be doing this kind of work in coordination with the national risk assessment, hopefully a little more timely than what we've seen. But frankly, the concept to me is very appealing. It should be done in all major provinces nationally in order to bring together, and even federally, I think something along those lines should be considered so that as a nation, we can work in a better coordination and sharing of information with respect to the national risks, threats, and what's going on, what should be done among regulators as well as law enforcement. So I'll leave it at that. It's a long answer, but certainly you can see where I'm going with this. I really like this package of 3 recommendations.
Right. Thanks for your comments, and certainly a lot to think about there. One thing I want to highlight in the comments that you made, and I'm going to move next to Garry and Christian for their comments on this concept, but just something that I'm hoping that we can bring into this discussion is, you mentioned there was at least six agencies or crown corporations which the commission recommended be given a legislated AML mandate. And one thing I would like to the panelists to comment on as we have this discussion is the difficulties or challenges in developing AML expertise in regulators and institutions that have not traditionally been focused on AML as their primary business for good reason. They're running other regulatory agencies with other focuses. So that's just a comment. So just inviting any of the panelists to speak to that. Maybe Christian, can I have your thoughts on this idea of the AML commissioner?
Yeah, so that's probably a good segue here in the sense that, so federally, there's 13 departments, agencies, organizations that have a financial crime mandate. Pile onto that the various provincial entities. So if you look at Accès Tabac in Quebec, for instance, where there's 22 different provincial organizations that are brought together, bring in local entities, territorial entities, indigenous enforcement entities. This is a very complex space, just from a pure bureaucratic, intergovernmental, administrative perspective. And so certainly I think one of the things that the commissioner can do is help focus the mind and make sure people sort of keep their eye on the ball, because I'm sure, as we hear from Garry, one of the big challenges is always that either organizations or government and politicians these things sort of come in waves. And so for a while, people pay attention and then sort of they lose interest, or we just don't have enough resources. So we shift all the resources to some other type of priority. So I think there in and of itself, there's an important coordination function to be played. I can understand why it's an AML commissioner, given the mandate of the Cullen Commission. I would have probably preferred to see something broader, a financial crime commissioner or so, or a crime and corruption commissioner. This would be more in keeping, for instance, with the way our Australian colleagues in the 6 Australian states have approached these types of issues. So I guess in good Canadian fashion, we want to start to walk before we want to start to crawl before we walk. So I can see sort of the limited mandate, but I think there's I'm not sure that limiting the mandate will actually get us the payoff that we want, because then immediately you're going to get into arguments about where do you draw the line, as between on restricting it to money laundering versus sort of does it sort of fall outside? So why not give it a broader mandate to begin with? Because we don't want to ignore some of the other sort of challenging issues in this space. So think about the terrorist financing element, but think also about tax evasion and aggressive tax avoidance. And of course, we know in British Columbia, we've had significant challenges on those fronts too. And so here's a commissioner who can perhaps point out practices that might not be necessarily criminal, but might be bordering on the illegal or so, and help rein in sort of some of the issues. The second is, as Denis has pointed out, and I think this is really important, and this will be lost on people, that this is an independent commissioner who is reporting to the legislature. Now, we've seen this proliferation of bodies reporting to the legislature. And I think from a democracy perspective, that's a good idea because it provides greater transparency. But if you look at Ottawa, at the number of entities, in particular the proliferation of entities, and every time it seems that we have a problem in government now, the solution seems to be, well, let's have another sort of independent body of the legislature. And I would say by and large, yes, they're good for transparency. They haven't been particularly good at affecting change. And so I'm not sure if you want to affect change, you're ultimately going to have a mechanism that reports to the executive. But that mechanism would necessarily look different. And there's pros and cons. So if you look, for instance, in the United States, we have czars, we have the tobacco czar, we have the drug czar. So these are entities that report to the executive, but as Denis rightly points out, they are then also beholden to the politics of the day to some extent, and to the shifting political priorities. So there's there's trade-offs here, and Justice Cullen, the Commission clearly made a very informed choice, and so I think opportunity for the audience to reread also the rationale for the choice that the Commission made here. And the last point to make is I'd already brought up Australia. So it's not a czar. It is not an entity that reports to the executive, and it is also not an investigative entity. And that's, I think, also important because, for instance, our colleagues in Australia, in addition to law enforcement capacity, have crime and corruption commissions that have very significant investigative powers for a host of reasons that come out of particular endogenous sort of reasons in Australia, but also on the understanding that these are very complex investigations. And so can we get from law enforcement what we actually need? I know that's a conversation we're gonna have subsequently. But so the commissioner also made a choice not to give the commissioner investigative powers. So coordinating function. And so then we need to think about what is the ultimate objective of the commissioner. Is it supposed to help us coordinate? So then basically making sure that agencies exchange information. Is it to cooperate so that agencies actually build parallel structures so they can talk to each other? This is part of the recommendation about the liaison individuals in each of the departments. Or is it collaboration where we actually build joint entities in order to go after a particular problem? And so I think there's still space to be defined for that commissioner. What exactly would we want the end game, the aim of the commissioner to be in this space?
Great. Thank you so much, Christian. I just want to make a note that I'm going to come back to your comment about the lack of investigative powers. And I might come back to you in a moment after after Garry's had a chance to weigh in, and just in particular for audience members who are not constitutional law experts, or might be constitutional law experts, but not in the Canadian jurisdiction. I'm just going to ask you to speak briefly for some of the reasons that there might be for separating investigative, for not giving that commissioner criminal investigative powers. So I'll just, that's just a forewarning. I'll come back to that, and it'll be a nice transition into the next topic about the dedicated provincial investigative unit. But Garry, I saw you nodding along there to what Christian was saying. What can we have your thoughts on this idea of a commissioner, an independent body reporting to the legislature?
I echo a lot of what Christian said, and that's probably why he and I get along so well. But that being said, a couple of things. Look, I don't think our federal government has yet to take this all seriously. So I think that's number one problem for anybody that's going to be in this capacity. I can tell you that during the commission itself, I did have an opportunity to write into our premier in Ontario and suggest that we really need to do something very similar, because exactly what was found in BC, believe me, it exists in the other provinces. So I guess my concern is this: that BC, I laud what was done. I think it was, I think Premier Eby got outside of the box and he did what needed to be done, and I laud him for that. I think this commissioner, though, we really need to have somebody that is going to keep this momentum going and keep it in the forefront, because otherwise I can see it dying a slow death for a lot of the reasons that Christian enunciated earlier. And I also agree with him. I think it should have been a broader mandate. Money laundering requires offenses. Money laundering requires all of these other ingredients, and it really focuses on that financial crime in its totality. And corruption is all part of this. So I think it would have been nice if this could have been a broader mandate. I do understand Justice Cullen's reasoning, but I think in time, I would hope that is understood and they look at broadening it out. I think this commissioner will have his hands full, because financial crime, and we're going to get into that, I know, later, but financial crime is not it doesn't have a border around it. And I think that could lead to being problematic. And how do you liaise? How do you look at a lot of things? So I think the commissioner's role is crucial, but I'm not sure how effective it will be if you look at what the ingredients are for financial crime and where that leads you to. I'll leave it there because I don't want to get into the other areas.
I have an audience question, which I'd like to pass on. It's a good one. They're all good ones, but this is particularly directed at you, Denny. I'm sorry. You have your hand up, so I'll ask the question, and you can get both of your thoughts in. Hopefully, do the panelists? The question is: do the panelists, particularly Denny, have a view on how provincial officials, the commissioner, and the AML liaisons will be able to interact with federal agencies that have inherent limitations on information sharing, FinTrack, CRA, huge limitations, both of those, what they're able to share with other entities. And that question is directed at you, Denny.
That's a great question. I'll try and answer that because, there's a lot in the role of the AML commissioner, but let's start with one of the roles that the commissioner is supposed to play, and that is basically keeping an eye and a focus on what's happening in the province insofar as money laundering is concerned. And as a result, one of the recommendations from the commissioner is also to monitor what's going on with the regulatory bodies. So from that perspective, I see a lot of opportunities to share that kind of information with the federal government without any difficulty. We're talking about strategic information, trends, risks, etc., as well as any information about the performance or effectiveness of the regulatory bodies. And we'll talk about this later, I'm sure, and that's the fact that the commissioner would be supervising supervisors in various fields, sectors in the province. So sharing that information with the federal government, particularly FinTrack on their compliance operations, I see pluses. With other regulators concerned with money laundering, and the same with the fact that there will be a statutorily appointed liaison officer in each of the provincial regulators. So that then again, it basically brings the focus on what's happening in the regulatory field. With respect to the steering committee, those are deputy ministers, committee and a secretariat. I see advantages to them basically sharing information with the federal government in terms of the kind of actions that they would want to implement in the province. And my one concern is that, and I'll join in what Garry said, sometimes, you wish the federal government would take a lot more action to prevent the province to say, look, you're not going to do it. We're going to have to do it because the problem is we're feeling the hurt and the harm in our own province. And I can tell you that back in 2018, the Department of Finance had proposed a list of gaps, of remedies to gaps in terms of anti-money laundering, and the government never approved them, or it hasn't moved forward with them, except maybe one, and that's armored vehicles or carriers of cash and that kind of thing. So I guess I see opportunities for great collaboration. I don't see a lot of impediments legally. The one thing that we will have to consider is if you're sharing tactical information, that is, of course, something, there's always a need to know, and all the protocols that exist between law enforcement, sharing information, and the fact that, and we can talk about this later, and that's a Supreme Court decision back in 2002, Jarvis and Lynn, and that's the idea of what is the relationship going to be, sharing information between regulators and law enforcement in the pursuit of criminal investigations, and the inherent, I would say, potential impediments, and in fact, you can screw up a whole investigation if you don't pay attention to that. So I don't know if I've answered the question properly, but I tried to anyway. And if I may, I would simply add to the comment that Christian made with respect to the mandate, as well as Garry expanding the mandate. I agree. Yes, we're very prudent in Canada. We like to crawl, maybe before we even walk. But in this case, if there was something missing in and it wasn't part of the commissioner's mandate, it was anti-terrorist financing. And so that I see as a must. If it should be an AML, ATF commissioner. Otherwise, everybody else who's supposed to be regulated in the province, or some of them, are actually implementing an ATF regime, or working to identify terrorist property, it's terrorist financing, etc. So I think that as a minimum should be added. As to a broader mandate, I think time will tell.
Thank you. Denis, I'm going to pick on your knowledge, your extensive knowledge of FINTRAC and the federal regime. Maybe for the benefit of audience members who don't know, can you name some provincially regulated players? I'm thinking principally private industry that are not currently covered by the the proceeds of crime legislation, and don't report to FINTRAC, where this might an AML commissioner might be filling some informational gaps in liaising with them about their AML responsibilities.
Well, I'll name one that is obvious in the Cullen report, and that is luxury goods. And that's just one, and there are others. For instance, the whole business of art and luxury goods and that kind of thing was reported back in 2018 by the Department of Finance as a gap to be closed. And in the province, that is something that the commissioner has identified as, look, if the feds aren't going to do it, we should do it, because there's an issue there, and that isn't covered, and it should be. Personally, I think it should be covered by the feds. It's going to make life simpler, because if you cover it in the province, you're going to people will move to the next jurisdiction, and you're going to get diversion, and you really haven't accomplished much. In terms of other areas in the province, you've got unregulated mortgage lenders, which isn't covered nationally either. And that is something that I think should be covered certainly in the province if the federal government doesn't do that, although they've announced that that would be something that they'd be looking at. But it hasn't been done, and haven't seen any regulations on that. Same thing, pari mutuel betting and horse racing. That's not covered by the feds, but is something that potentially should be, and I know it's been covered in the German report. So those are areas that aren't covered and should be, in my view.
Okay. I've got an audience comment here, and it says, I view the creation of a BC provincial AML commissioner and a dedicated investigative unit as a useful symbolic step, but substantively I see much redundancy and overlap. Granted, it will help to keep a political focus on BC money laundering problems, and it will keep the pressure on FINTRAC, the RCMP, Department of Justice, CBSA, and others, which is much needed. Unless the BC dedicated unit is provided access to STRs and RCMP investigation files, which in my judgment won't happen and shouldn't because of redundancy, confidentiality, and jurisdictional concerns, will that unit be fed with hearsay and anecdotal information? This would be counterproductive. I think those last comments, I think, about the information, I think that's directed to the concept of the investigative unit, but and we'll talk about that. But Garry, I thought maybe I might get your thoughts on this comment about you know what let's actually just hold that thought for a minute. Because we will be talking about the investigative unit next, but I do want to draw one thing out of this comment, which about STRs, which of course are suspicious transaction reports. Suspicious transaction reports are made to FINTRAC, and FINTRAC can then provide information that's collected that way to law enforcement to condense a sophisticated process into just a couple of words there. One of the ideas that is suggested in one of the recommendations in the report is that there be a provincial reporting regime for cash transactions, any cash transaction, $10,000 or more, and that would apply to the luxury goods area, that gap that you just mentioned, Denny. And the commissioner recommended, Commissioner Cullen recommended that the AML commissioner have access to those $10,000 and up cash transaction reports as part of the information accessible or required to make its assessment of to develop its strategic intelligence. And I just, and again, simply because of your extensive experience with FINTRAC, Denny, I wanted your thoughts on that process and the intelligence that could be derived, and whether you see that as being a useful source of strategic information.
Well, I think it's, that's why I was hoping that the federal government would implement this. And so therefore there would already be a mechanism to collect this nationally without any issues of people going to another province to buy their yachts and boats and other high value goods. But I think, so that would have been the ideal situation. But if not, if it's, as the commissioner says, look, the feds won't do it, we'll do it here. There's still that issue of divergence. And so therefore the reporting will require some kind of regulation. Otherwise, and therefore the commissioner will have to set, in my view, if you want reports, you're gonna have to set up a compliance unit that's gonna basically ensure that those who are involved in that sector produce those reports and produce them properly, and then, send the information electronically in a format, the whole bit. And then you've got the information management issues to worry about, validation of data when it comes in. I mean, how many luxury good vendors and sellers are there in the province to start out with? So I don't know what the scope is, but I do think that it is a good thing to look into. Certainly there's going to be some complexities, and whether or not they want to advance it, maybe push the federal government to do this, which the finance department did advise, like I mentioned back in 2018. And so it'd be nice to do that at the federal level. But if they don't, I do think that it is something that they should look into. but it brings a lot of complexity in terms of setting up. Otherwise, what happens if you don't send in your report? Are there consequences? Will there be sanctions? And what's actually going to happen? You know, we always, in the compliance business, you always think that people are going to willfully comply. But the reality is there's always some people who won't. And so what do? How do you correct that behavior? And otherwise, if you don't, it's a competitive disadvantage to those people who are actually running their business honestly and are following the rules. So that's one of the complexities I see with that particular recommendation. Although I do see some usefulness in getting and looking into that and seeing what the landscape is in terms of the value of that information in the different markets that should be looked at. Preferably, the federal government should do it and save the province that trouble, but also work with the feds to make sure they get information about those $10,000 plus, and also virtual currency. The commissioner didn't mention anything about payment in virtual currency, well, at least I didn't notice that. So it's not just cash. There's other means of payment. And so in this particular case, it could work with the federal government to, if they do implement it, to identify specifically what's happening in BC. And I think that would be a requirement, is provide BC intelligence and investigation unit and the commissioner with that kind of information, both in a strategic manner, trends, etc., and the intelligence division, make sure they get names and eyeballs and whatever it is associated with these reports.
Thank you. And finally, before we move on to the dedicated investigative unit, one comment the commissioner makes in the report is that he saw no reason in principle why the Law Society of BC wouldn't be subject to the same type of evaluation of AML mandates and oversight as other regulators. And that, in his view, this could be done in a way that does not undermine legal privilege. Of course, lawyers are excluded from the proceeds of crime, money laundering, terrorist financing regime in Canada for various reasons set out in the Federation of Law Societies case from the SEC in 2015. And I think maybe I'll direct this question to Garry about what you think about this, the AML commissioner having a role in providing more oversight of the legal profession when it comes to its money laundering, anti-terrorist financing obligations.
And just so you know, I've had many chats with Peter German on this. So I recognizing that I had an opportunity, I was one that actually testified on behalf of the Crown when we went through the challenges by the law societies. And I realized that there's no point in going back to the table the Supreme Court has ruled. So we need to look at a mechanism. I do think this is a palatable mechanism, and I don't think it's in violation of what the Supreme Court has said. So I do think it's necessary. I mean, I can tell you, I've never done an organized crime case that there isn't a lawyer involved. And that's not to say that we're talking the whole community, we're talking a small proportion, but that small proportion does a lot of damage. When we recognize that you cannot money launder without use of the professional community, it can't happen. You got to set up companies, you got to set up various offshore sites, you need your accountants, you need your lawyers, and that's how it's done. So it's an area that's a huge gap. I think it's a gap that is an impediment to Canada's regime.
Right. Thanks. I'm going to come back now, Christian. I think Denny touched on this, the reasons why there might be one body has the ability to gather and produce strategic intelligence, and another body has the ability to gather and share tactical intelligence. And I'm wondering if you are, and I'm sorry to put this on you, give us a nutshell explanation of why that divide exists.
Can I react briefly to a couple of the previous conversations?
Oh, please
and then,
do, yes.
And then I'll keep my comments on the intelligence brief, and then because I'm sure Garry will complement that quite nicely. So I don't see any reason why we can't write legislation that actually withstands sort of the Section 1 and sort of a reasonable limits sort of test on this. Given, I think, the evidence that is now before us in terms of the harms that is being caused. And I think it is possible to write legislation that could charter-proof this in a way that sort of addresses some of the concerns about some of the professions. So I think this argument that some...
So are your comments there directed towards the legal profession's involvement in the proceeds of crime regime? Yeah,
so I mean, of course, I'm not a lawyer, so you'll know a lot more about this, having clerked at the Supreme Court. But I think it is not. It shouldn't be beyond trying. I think there's just not been a will by government to actually make an attempt to try to see if we can actually craft that in a way that would actually withstand judicial scrutiny. And on the cash issues, I found this recommendation a bit puzzling because it's going to create. So we already know from the banks don't particularly like the $10,000 limit for money that comes in and out of the country because it's arbitrary and it creates a sort of major reporting onus. It's actually much easier to report on all or none of the transactions. So in Australia, they've just dropped the $10,000 limit. When money goes in and out of the country, you just have to report it, period, right? It's easy for the banks. They can capture everything. They can just report it. So here, I think on the cash reporting, look, I don't carry $50 or $100 bills in my pocket. I've testified before a committee that we should just get rid of $50 and $100 bills. We don't need these large denominations. The only people that it benefits are the folks who use it illegally in order to move value. So maybe we could just, Sweden has gone the way of just basically all transactions are electronic transactions. Now, in some countries that's been proposed, Germany, for instance, and culturally that was simply not doable. So I think there's a cultural element to cash, but I wonder whether we can thread that needle by saying, you just can't buy certain stuff in this country with cash. When you're buying your $100,000 Benz and you're showing up with cash, maybe that in itself should be a flag. And so maybe, and where do we set the thresholds? If you look at your credit card and you want to get insurance on your credit card, you'll know that there's an exclusion on your credit card that any vehicle, for most credit cards, I think it's over $60,000, that's considered a luxury vehicle, is not covered. So you're going to have to buy your own insurance. And so, I think we already have a distinction of sort of what sort of reasonable use every day and what are sort of exceptional things. And so maybe we just say, if you're going to buy that sort of stuff, then then maybe you just have to simply buy it with an electronic transaction. And as Denis points out, then we need to be circumspect because there's a proliferation of crypto and other forms of coin, altcoin, and so forth, so that we limit that. But I mean, it works just fine in Sweden. Presumably we could probably implement at least some of it here and learn from that lesson. So on your question about sort of the intelligence on the strategic and the tactical side. So on the strategic side, first you need a capacity to understand, to have domain awareness and understand what your problem actually is. And so so if you're going to allocate your resources, you need to understand how sizable the problem is and how that problem is evolving. And of course, the bad guys, and yes, they usually are guys, adapt quite in a quite agile fashion. So having a strategic capacity to understand the space, understand how that space is evolving, and that requires you to have access to the necessary data, but it also requires you to have an assessment capability. And we generally in this country tend to do quite poorly at strategic assessments, especially in strategic intelligence assessments. Other countries actually have entire assessment directorates. In Canada, at the federal level, we have 4 entities that do strategic intelligence assessment. All of them are relatively limited and relatively small. So it's certainly something at which we do not excel in this country. And then we need to push those assessments out and down. And that's also something we do quite poorly. I think in the forthcoming report by the Rouleau Commission, we're probably going to have I suspect, some interesting observations about the inability to actually push the right assessments and the right information out to the right entities at the right time at the local level. A long-time complaint from local levels that they kind of feel abandoned by the federal government, especially when it comes to this sort of more complex space. So, and then you need to separate that from intelligence that's actionable, that you can use to get over the threshold to start an investigation, to get over the threshold to get different types of warrants that you might need. Maybe not all of these need to be for the purpose of criminal prosecution. We have some good experience here from CSIS that maybe on some areas we just kind of need a higher level intelligence awareness, and then being able to push that to enforcement agencies that might actually want to do something with this. And the reason why I mention this sort of distinction is we always think we want to lock everybody up. But in this particular space, when it comes to money laundering, financial crime, the single most expensive and onerous solution is to try to lock someone up. And it's going to be quite uncertain in front of the courts, given the way also our legal regime has evolved, and something that Garry can comment on. So there's lots of other approaches that we can take. We can take disruptions approaches, interdiction approaches, that don't necessarily require perhaps as an end goal to throw someone in jail. And that's why the previous conversations about unexplained wealth orders, proceeds of crime and so forth is so important, because I think these are one way to disincent this type of behavior is simply to take some of the things that people have gained and just show them that it's simply not going to be very successful in this province to do that. So I think that's a conversation about what are the ends that you want to achieve. But so there's good legal reasons, there's good strategic reasons, and there's good investigative and enforcement reasons why you need to make sure that you have regimes that serve different ends within different institutional setups. And this might be a good opportunity to, I guess, punt this over to Garry. I also want to, also mention that our original testimony was, of course, with my late friend and colleague, Art Cofield, and I also see Jeff Simser is with us sort of in the audience, all people who've made very important contributions to thinking through this very complex space between intelligence investigations and how you set this up so it's legally compliant and it's effective.
I think now, Garry, unless you wanted to respond directly to that, I was going to move the discussion forward more formally into the investigative unit. And so, Justin, if you could pull up the recommendation 91 slide. All right, so this is a recommendation that the province create a dedicated provincial money laundering intelligence and investigative unit to lead the law enforcement response to money laundering in this province by identifying, investigating, and disrupting sophisticated money laundering activity. I think, Christian, that word disrupting goes back to your previous comments about there could be larger goals than charging people, putting people in jail, and B, training and otherwise supporting other investigators in the investigation of the money laundering and proceeds of crime offenses. And then I think there's a couple of related recommendations. I think just in the next page has 94. A recommendation that the province ensure that there is sufficient surveillance capacity within the Combined Forces Special Enforcement Unit to support the work of the new dedicated provincial money laundering intelligence and investigation unit. And the next one, 95, that the AML Commissioner conduct a comprehensive review of the provincial money laundering intelligence and investigative unit every 5 years to ensure that it remains relevant and effective. So kind of connecting those two institutions that we're talking about today. Thanks very much, Justin. You can go ahead and take those down. I'm going to start by asking Garry if you could situate us a little bit historically in terms of how it is that we ended up. I mean, there's reasons, of course, that the commissioner recommended a provincial investigative unit. The commission had a mandate which was provincial in nature, and couldn't was limited in terms of making recommendations to the federal government, but just also historically, I wonder if you could just give a recap of federal efforts to maintain an investigative unit looking at money laundering and proceeds of crime, and just give that factual context of how we end up here today.
Just very quickly, because I could be a half a day talking about it. Very quickly, it's it started out under the drug enforcement regime as an anti-drug profiteering program, and it sort of transcended from there into what became known as the integrated proceeds of crime, and that it sort of was spawned because through the anti-drug profiteering, it was recognized the special skills that were required, the need for especially dedicated prosecutors to be part of it, the accountants to be part of it, a municipal, provincial police, tax, and our customs enforcement body. And we put all this together. And I can tell you back in the early stages, early 90s, late 89s, early 90s, we actually were looked at around the world as having a very effective and efficient model. The money was what they called fenced funds by the government. It had to report yearly to Treasury Board. So it gave some impetus for this unit. Then the erosion started. And the erosion started understanding that where RCMP was, and I still think for the most part, a paramilitary organization. So promotional opportunities were more forthcoming outside of that proceeds of crime regime. So trying to keep bodies of expertise. We essentially we're in a constant training mode, turning over bodies about every 3 years. And I can tell you, this is going to be the issue when BC tries to set it up. This is not something, it's like saying I'm going to take a brain surgeon and they're going to be an accountant tomorrow. It doesn't work that way. We need specialized training. My argument was, and I was able to demonstrate it during my time in the RCMP, take a competent investigator. They need 5 years of experience in the money laundering proceeds of crime arena to be an effective investigator that they can go and do an international investigation. And that's understanding that most of these are going to end up international. We never got there. The turnover was unreal. Government didn't fund it. There became vacancies. And as a result, there was a dissolution of the whole unit. That's going to be the issue it's the issue today for Canada. As a result of that unit dissolving, we've become a haven for transnational organized crime. And I think British Columbia, unfortunately, has been a target for a long time. Asian-based organized crime is just entrenched in British Columbia. You're seeing the fentanyl crisis that comes out of China. How do you get now an investigative body up to speed overnight? It's not going to happen. We talk about intelligence and keep feeding more and more intelligence into FinTrack or a provincial body. My argument is this: we build a Rolls Royce, it's called FinTrack, but the real measure of it is the engine that drives it. And the engine that drives it has to be enforcement and prosecution. And I hate to say it, but that's almost non-existent in this country today. I've made some strong arguments. I know there's arguments on both sides, but we really have to get over the being enamored with the red surge, the RCMP, and recognize we need a federal force that is dedicated 100% to federal enforcement. And that's what this begs to have. I think anything short of it, it's not going to work. And we'll be just talking about this for the next decade. And that's my concern with the provincial mandate. As I said, I admire what they're trying to do, but provincially, they have to understand that this is an international arena when you get into transnational crime. And so how do you make that liaison? And bottom line is, who are they going to liaise with? Where is the liaison going to take place? Who in federal government is going to step up? Because we still haven't got a federal government that's financing anything. And if you look at the state of the RCMP, their whole focus has had to be deal with the crises around contract leasing. So we don't hear much about an effective federal side right now. Not that the abilities aren't in the organization, it's just leadership is making it happen. I'll leave it at that, and happy to weigh in on other things.
Yeah, just want to mention there's a comment from the audience that the Financial Action Task Force evaluations of Canada state that we're compliant in some ways, but we're lacking a record on money laundering convictions, echoing your comments there. Christian, I might have been misinterpreting, but it looks like you were eager to jump in on Gary's comments. And just before you do, I want to mention that, of course, you and Garry and your former colleague Art Cofield, who you mentioned, and Jeff Simser, who's in our audience and is feeding me great questions, prepared a report for the commission about proposing an anti-money laundering institute, an investigative body as a solution in the law enforcement enforcement area. And maybe just if I could ask both of you as we discuss this proposal, if you can highlight places where the commission's recommendations diverge from what you'd recommended, if you think that it's improved at all on it, or has fallen short by leaving certain aspects of what you were envisioning out. So Christian, have your comments, your thoughts generally on this investigative unit.
So there's the administrative side of we spent a lot of time trying to figure out how do you actually set this up, because I think part of the challenge is I often find, like, when you talk to government, they have sort of a broad idea of what they want to do, but then they're really down in the weeds. And so operationally, how do you make that connection? And so helping people wrap their mind around this is actually doable from an institutional standpoint, from a legal standpoint. And at the same time, it's meant to remedy a number of the issues that have already been brought up. So these investigations are extremely complex, financial crime investigations. Some countries have gone to the point of having an entire separate police force that is dedicated simply to these types of investigations. So how are we, in light of what Gary's pointed out, that sort of the revolving door problem, the inability to keep people, the long time it takes to train people up, the fact that sort of in the current in the current promotional structure within the RCMP, there's no incentive for people to stay. The incentive is for them to get promoted, to make more money. So how do you set up an entity that gets us sort of out of some of these bedeviling problems, where we can actually have people who can effectively become financial crime professionals, and recognizing that for much of this, we actually don't need people in uniform. We actually need people who have very specialized, highly trained skill sets. And then we probably need the odd member in uniform with experience and the odd experienced crown to help guide these types of investigations. So how do you actually get the skill sets in and get us out of some of the challenges that we face there? But how do you also get us out of the challenge that, and I know Denis has views on this, we have a very particular setup federally when it comes to financial intelligence. No other democratic country has chosen the approach that we have taken, which is first and foremost an administrative unit, not an investigative unit. And as I mentioned before, the Rouleau inquiry, for instance, the Rouleau Commission, we have a disproportionate amount of input in terms of financial intelligence in this country. I think something like 32 million reports last year. And we have a disproportionate small amount of output. Now, of course, FinTrack will point out that these 2,000 sort of elements on the output side may contain many hundreds of pages of documentation or so forth. But we have a very reactive system. And a reactive system is unlikely to work if you're trying to build a more proactive, engaged intelligence, financial intelligence sort of capacity that also has real investigative and disruptive sort of powers. And so if we're not going to get from the federal government and from FinTrack sort of what the entity actually needs, how can we build some of those capacities internally within that entity and then work with what we got in terms of, for instance, making better requests to FinTrack so you can get more responses from FinTrack and you can get better responses from FinTrack. So how do you make the system that we have work from a provincial perspective? And that was, I think, also a major impetus behind sort of how you actually, how you set that up. I think the final point is, I think people are disillusioned. And when we have these conversations, I think we underestimate the extent to which money laundering, financial crime, corruption, terrorist financing, as Denis mentioned, aggressive tax avoidance, to what extent that delegitimizes our democratic institutions. And so the ineffectiveness that's mentioned in the FATF country report isn't just sort of a simple data point. It is an indication of why people are disenchanted with our democratic institutions, because why would I pay my taxes when the wealthy get away with all sorts of ways of circumventing them? And the frustration of crime in our streets, and the heinous consequences for local communities when we can't get a handle on the back-end financial motives that drive much of the violence and much of the social tragedies that we see in our communities. I know Mayor Brad West, for instance, Port Coquitlam, has been very outspoken on some of these matters. So that's sort of the broader motivations behind this.
Denis, I see you have your hand up, and I thought you probably want to respond.
Yeah, thanks, Eileen. Thank you, dear colleagues, for your comments. I certainly want to comment on what you said, Christian, with respect to FinTrack, but also in terms of Gary's comment, excuse me, with respect to the flow of information from FinTrack to law enforcement. Now, I haven't been in FinTrack in a while. I do follow what's going on, but I've always seen, even when I was there, because I've done both functions, the compliance, if you wish, at the Chief Compliance Officer, that wasn't my title, but that's essentially the function, but also the Deputy Director on Financial Intelligence. And I can tell you that what it looked to me was basically a fire hose of information, financial intelligence, that was going to police agencies as well as other designated recipients, CRA, CVSA, others that were entitled to receive this financial intelligence. CSIS, of course, on the terrorist financing, which is a priority. So I saw this basically as a fire hose going to law enforcement. And the unfortunate part is that we knew that law enforcement had cases up to their anyway, overloaded, I won't use the word, but they were just submerged with cases. And the same thing with in cases that law enforcement, very complex cases, bringing them to prosecutors. So there was a lack, in my view, of prosecutors, judges, to handle a lot of these cases, and specialized prosecutors, not just to help on the investigative side, because you can't have a prosecutor working on the investigation, jump the fence, and then go litigate the case in court. So you needed to invest in prosecutors and investigation teams, and then bring it to public prosecution service to have another prosecutor take the case. But you also saw, I did certainly during my lifetime, different approaches by different prosecutors in different provinces, personalities, some having a very low level of tolerance for risk in terms of taking the evidence. No evidence is perfect, but you have to build the arguments and take it forward. So that, and then move that to prosecution and have your case, heard by the judge. And in this case, the amount of information that was coming from FinTrack as a result of private sector investments providing information to FinTrack was, yes, tremendous. However, FinTrack also receives more information than the vast majority of financial intelligence units in the world. I'm not here to defend FinTrack, but I just want to express my perspective as I worked there. And incoming and outgoing EFTs, which are electronic funds transfers, are collected by the vast majority of financial intelligence units. And so therefore, that's why the number of reports, if you wish, cases or transactions that are collected by FinTrack is enormous. It's in the mid 20 million a year at least. And so when people make comparisons of the number of reports that are received, managed, information managed, and has to be destroyed so many years later, compared to other jurisdictions where they only get STRs, those comparisons in terms of the volume of information received and what is pumped out, at least these days, I think it's over 2,000 disclosures to law enforcement, not just to the RCMP, terrorist financing, as well as threats to the security of Canada. Most of it is money laundering. So I agree, there needs to be more resources put into investigative and the judiciary to handle these cases. And I think that you might end up seeing some better results, including all the recommendations that Garry has mentioned in terms of helping move the needle in terms of number of prosecutions and the number of successful ones in dealing with transnational organized crime. So I just wanted to add that. And later on, I may have a comment on LSBC and why it's necessary to have an independent person identified as a statutory liaison person for the AML Commission.
Garry, I think you've indicated you want to respond to that. Oh,
sorry about that. The one comment I want to make, I think is also crucial to understand. It does matter whether it's provincial or federal, but the one thing that we've really got to come to grips with in this country, and I used the term when we were preparing for this, I sent it in, and one of my comments is that if we really look at some of the things like Jordan and Stinchcombe and some of the cases recently that have been thrown out of court because of time constraints, and there's a lot of reasons for it. One was a recent one, a murder and drug investigation, because the provincial court judge took so long on a decision. I would argue that we talk about bringing the administration of justice into disrepute. Well, justice has brought itself into disrepute. And I think it's time that we have a wholesale look at our system, because what we've done is we've opened the floodgates and we've said to transnational organized crime, we are incapable of taking you on. So please come into Canada and launder your money. And it's a sad commentary, but it's the absolute truth.
Great. I wanted to follow up on some of the comments about developing expertise and the problems with retaining people with expertise in a particular unit, and translate that into a different thought, a related thought, which I'm going to direct to you, Christian, about the kind of intelligence and data managing capacity in terms of technology and also just personal expertise that is required for a successful intelligence unit providing tactical intelligence about developing tactical intelligence about money laundering.
Look, that's a great question. And I think it flows really nicely from the previous conversation, because I think one of the things that we learned in this country, much of this, you heard from Denis, like, it's not fundamentally a data problem. Much of this is political will. And we have an example in Canada where politicians put their mind to it and they decided this simply isn't acceptable. And that's terrorism. Right? So if you look after what happened after 9/11, the changes that were made, we have integrated national security enforcement teams in 4 major cities, and then we have smaller units in other communities where we bring together an interagency setup, including with international partners, so that so it's simply to show that when government does, so it's not impossible to do. When government wants to put their mind to it, we can have the legislative change, we can gather the necessary intelligence, we can have the enforcement capacity, and by and large, we can also have the prosecutorial success. because by and large, it's most of the things that have ultimately come before the courts have been prosecuted successfully. And in a space where, similar to financial crime, I mean, the difference with terrorism is that we want to prevent a particular type of activity rather than prosecuting it after the fact. And so I think this is part of sort of the conversation about, so how do you actually set up an entity that is not just acts on a deterrent basis, but can actually detect early on and then run interference, disrupt and so forth, so you can actually be proactive rather than always being reactive in the space. And I think was it Denis or Garry who already mentioned sort of some of the problems around sort of the money laundering sort of legislation, and you need to have a precursor crime. And so increasingly, of course, you have laundering that doesn't have a precursor crime. So it's then hard to get a handle on it, because if you can't prove the precursor crime, then it's going to be hard to prosecute it for laundering purposes and so forth. And data is key, I think. So Denis' observation is really important here on sort of the electronic funds transfers, for instance. The amount of data in the financial space, now that you also add crypto transactions and so forth onto that, is fantastic. And so how do you bring together, so there's a methodological challenge here. Everybody has different data sets. So these data sets are heterogeneous. That is to say, they're not all coded the same way. So just bringing them together in an intelligible and intelligent fashion so you can actually do something with it requires a fairly sophisticated analytic skill set. Otherwise, you can throw all the data together, but garbage in, garbage out, as anybody who works in the space will tell you. And the other problem is that they're heterogeneous. That is to say, they have quantitative data and then they'll have qualitative data. So bringing all this together is doable, but it's tricky. And you heard from Denis that one of the challenges on the financial side isn't necessarily sort of the data flow, but what do you actually do with those data? And can you actually translate that data into something that is meaningful, either strategically or tactically, let alone then collate that data with other forms of data? And you heard from Garry, for instance, about the IPOC. These are interagency entities. So you need to bring together a whole host of data. And especially if you want to do this intelligently at the strategic level, so you get a sense of the domain awareness of what's happening in the space. And then you need to do it not just intelligently at the tactical level, you also need to be able to do it legally at the tactical level, so it doesn't fall apart when you're actually trying to then take someone's assets, engage in civil forfeiture, either civilly or criminally, or you ultimately try to prosecute. And so cracking that, that's a really tough nut to crack. And just like you require very experienced people on the investigative and prosecutorial side, you require people who really understand data in order, I think, to have not just a genuine impact, but to make sure we don't just pick the lowest hanging fruit, as we often do, like with drug investigations, right? We pick sort of the people we can actually pull off the street as opposed to the big fish behind it, that we can actually have a full appreciation of the domain and go after the kingpins and some of and that requires a relatively sophisticated understanding of data. The good news on this is, in particular, the Sûreté du Québec has made significant inroads on organized crime because they've wrapped their heads around things such as analytics and social network analysis. So it is doable, it is possible.
Thanks, Christian. I want to return to the idea of the effectiveness, the potential effectiveness of an investigative unit that's really provincial in nature. And I thought maybe one of the ways that we could explore some of the difficulties would be, Garry, I'd ask you to discuss, and I know you could go on for days about your experiences with IPOC and your investigations there, but if you could just give us a sense of how investigations, money laundering, proceeds of crime investigations quickly extend outside of a particular jurisdiction. And I wonder if there's just give some color for that.
Sure. Well, you take a look at any and not even sophisticated, any of the organized crime groups today. When it comes down to money laundering, the first thing they want to do is they want to conceal their money. So they're going to look at all the various ways we've heard about for years and years and years. They're going to look at offshore jurisdictions. They're going to look at setting up shell companies. So all of this immediately takes it from downtown Vancouver in the case. And a good example is because you do have a significant Asian organized crime problem in Vancouver. You take a look at it, and a lot what came out in Cullen. Where was that money going and how was it moved? So take a provincial jurisdiction or a provincial body that's going to investigate that. Immediately, they have to have capacity to liaise with overseas entities. And, the value right now that should be there for everybody's use is the RCMP's International Liaison Program, which is supposed to be assistance to law enforcement. But you have to do those things. The second thing you have to be cognizant of is that any evidence you're going to obtain or any request you're going to make, you're either going to do it through a mutual legal assistance treaty, and all of that evidence has to be gathered in a way that you can introduce it into the courts in Canada. So it's not just a matter of talking, and I've heard this before, well, it's a matter of having liaison with some officer in a foreign country. Well, that's not the case. It goes well beyond that. I can't think of an investigation that anybody's going to be involving some sophisticated crime group. And most of them today you're going to deal with, regardless of what you're looking at, whether it's cyber crime or fraud, every one of them is going to take you in some foreign jurisdiction or somewhere else in Canada. So the question that begs to be answered is, how do we bring all of that together that you can be effective and efficient? You can work in your own backyard, and that probably will lead to civil forfeiture, or as Christian has said, you can have your 1 hour in the sun where you do a display of guns seized and drugs on a table and say, we're going home, we're happy, but that doesn't solve anything. And so it's really important in my mind, and I want to emphasize that the concept of integrated works well. What a lot of people didn't realize, and I've heard it over and over again, that proceeds of crime investigations are extremely hard to prove. The answer is yes, to a degree they are. But here's where the advantage of an integrated unit comes in. And we were highly successful in our integrated unit in the National Capital Region. We worked in conjunction with our CRA partners in tax, and we had a prosecutor who's very good, and we respected 241 of the Income Tax Act. So tax didn't feed us. But when we would go in and sit down and talk a plea after we did an arrest, counsel would first thing to ask is this going to be a combined tax and a combined criminal agreement? Because understand that something we may not be able to get, they could get under CRA because you haven't filed taxes. Most of them never file taxes, or they file limited, and you got a massive amount of money. So under our tax act, you're required to pay taxes. So in conjunction with one another, you could have tremendous results. That's the value of working together, the value of having your municipal and provincial partners in the case of Ontario. It works effective, it's efficient, so it can be done. But what does that require? It requires money. It requires, as Christian has articulated far better than I would, very good people putting together initially the strategic, moving into tactical intelligence, so that body, which is an expensive body that's doing the investigation, is working on the individuals that are causing the most damage to a province, a city, or Canada as a whole. And that's what it takes. And we prove it can be done. It's going to take political will. It's going to take money. And right now, political will is in the province of British Columbia. There is, I wouldn't even say an ounce of political will on the federal side.
Denny, please.
I'll add to what Garry has said in terms of, as well as what Christian said, bringing together a group of experts in their own fields, giving them an opportunity to live in that organization and aspire to move into that organization, to stay there, not just on secondments for 1 year, 2 years, is basically to build a home, build expertise, teamwork, because I can support what Garry has said. Certainly, my group, my investigators were involved in one of the largest takedowns of the mafia in Montreal, the Projet Colisée, and the CRA was crucial in that particular investigation. And I know my team of investigators across the country also were very important, particularly in Vancouver and BC, in recuperating, working with the CFSCU in terms of getting money that would have normally been lost. The tax managed to pretty much collect everything and counted penalties and arrears, et cetera, et cetera. So if you can't get them one way, you get them the other, and basically take people's money away or the bad guy's money away, and that's an incentive. So I support the idea of bringing a whole bunch of different experts, because as Garry said, and Christian said, trying to get an accountant to become a brain surgeon isn't, or vice versa, isn't going to happen overnight.
Christian.
Yeah, there's too much of the taking people in their 40s and teaching them to play hockey and hopefully they'll make the NHL. But Garry mentioned it's going to cost money, but in practice, not really, because we're talking financial crime here. This will all pay for itself. It'll actually generate revenue for the province. It'll generate revenue for precisely the sort of programs that we would want to fund. And if you need a case study, look at Accès Tabac in Quebec, where the entire Accès Tabac initiative not only pays for itself, but has cut the problem of illegal tobacco in half and has doubled the revenue that the province brings in. So it's just as, there's probably other sort of nice case studies of the sort. And when it comes to working with the professions or so forth, as a federal model, the CCTX, so the Cybersecurity Threat Exchange, which is an interchange between the communication security establishment and some larger and now also medium-sized key entities that face a host of sort of cyber threats. They found a very creative legal mechanism in order to be able to exchange the necessary intelligence. Now, it's not necessarily focused in this case, of course, on investigations or prosecutions, but all that to say is we have some examples of creative thinking in this country where we faced particular problems, and whether it's INSETS or Accès Tabac or CCTX, and we put our minds together and we figured out within the legal regime that we have, how do we actually get a handle on this?
Interesting comment about seizure of assets, and I've had some comments. I just want to acknowledge that there's been a number of comments in the Q&A about civil asset forfeiture. There was a mentioned in the Cullen report with respect to the dedicated provincial unit that it could be expected that more investigative work in this area would lead also to more civil forfeiture cases, perhaps of a higher value that could help to fund such a unit. Just a comment from the audience says, how about we revise our expectations? Money laundering, proceeds of crime can be fought at municipal levels through civil asset forfeiture. Of course, in British Columbia, civil forfeiture office is a provincial office. Or criminal forfeiture when warranted. And I want to come back to Garry just with that thought in a second. Provincial work on larger scales and have limited expectations leading to the federal teams to take on international organized crime. So suggesting that we revising goals and expectations. Not everything has to be super high level to work. Various agencies can work at various levels. So an idea there that one way to be effective is civil asset forfeiture efforts at the provincial level, that you don't necessarily have to be taking down an entire organization in order to be effective. So thoughts on that, and also Garry, I want to come back to you in a minute about criminal asset forfeiture and just kind of the expertise that currently exists on the law enforcement side, both police and then prosecutor side with respect to those tools. And actually, so maybe we'll start with that and then let anybody else comment about the others.
Well, my understanding, and I appreciate I've been outside of law enforcement now for a few years, but my understanding, talking to those that are still inside, the RCMP ended up disbanding, unfortunately, all their specialized units and did this combined unit. There, I think you heard when during the testimony that I think there was 5 full-time money laundering investigators in the RCMP in province of British Columbia. That in and of itself is almost laughable, but we'll leave it at that. So that got watered down. I do know when we got rid of that concept of the prosecutors being attached to the integrated proceeds of crime and special prosecutors, these are complex cases. And so to be a prosecutor in this area, you've got to be able to stay in it and gain some knowledge and some expertise. If you're not doing that, the last thing you want to do is take on one of these convoluted cases. So I agree, and that's why things like offense-related property is highly used. That's why civil forfeiture is expanding. But what people have to realize, it's great you may seize a house through civil forfeiture and a few cars. That criminal element still exists. We haven't eliminated the problem. And so although I like civil forfeiture, if we can beef it up to a RICO type statute, if we can look at things like wire fraud, which really would help prosecute some of these things, because the minute you transferred your money, whether through the system, you've got wire fraud if it's illicit money. There's a lot of ways that we can look at it. It goes back to what I said. We need to really do a wholesale gap analysis. And I tried to insinuate that during my testimony, and I know Christian and I have talked about it. Let's do a gap analysis of what's missing. Let's look at what we can do in our own framework. And from there, I think, we're all smart people. We put that collective wisdom together. We can come up with, I think, some really effective tools. But the first thing that has to be done is accept that we have a lot of gaps and there's a willingness to do it. As I said, I think province of British Columbia has started down that road, but this goes far beyond a provincial responsibility. And I think we have to accept that and recognize that there has to be a federal voice in this. And, I hope it comes sooner rather than later. And in the interim, it'll be interesting to see how British Columbia can build this out to be effective. I do like, as I said right off the bat, I think the idea of having a commissioner or a czar is a great idea because it keeps it in front of our political masters. It keeps them on their toes. Every province needs this because seriously, the organized crime component, if I was to talk to the province of Ontario, I would suggest it's worse than British Columbia. I can tell you, I've worked prior to this job. I worked with some banks on doing their enhanced due diligence. You have no idea how many organized crime groups that I went back to banks and I identified for them. We have a huge problem in this country. And until we look at what the gaps are, we put, as I said, that collective wisdom in a room of how we can overcome some of this. We're in an uphill battle and we'll be talking about this 10 years. And I think we owe it to our children and our grandchildren to get this right, because if not, it doesn't bode well. Because I go back to the 1980s when the Globe and Mail came out, and I believe the figure was it costs every man, woman, and child in Canada $600 for the impact of organized crime. What would extrapolate that, and what would that be today? Because I don't think that's an underestimation. The Charbonneau Commission definitely showed what happens with corruption and how it costs the taxpayers millions and millions of dollars more. So those are my concerns. It's probably why I'm still working in this industry. It's why I collaborate with knowledgeable individuals like Christian. And I hope to see that before somebody plants me, that at least we've made some headway. And it is disheartening for me to see we we went so far and we seem to be becoming effective. And today we've really gone backwards in a really unfortunate way.
Any final comments from either? And I appreciate we could talk about this all day. You probably have many further thoughts. Any final comments that you want to make, Denis or Christian, on the dedicated provincial investigative unit before we move on?
Yeah, so I think this is very promising in the context of British Columbia, right? So it's the single largest provincial deployment of RCMP officers, and British Columbia, unlike other contract policing provinces, has always taken a rather dirigiste approach to their relationships with the RCMP, setting clear goals, setting clear expectations. So I think it is, especially in British Columbia, if it is workable in terms of the relationship with the RCMP in one province, then I would say it is the province of British Columbia. I maybe sum up like the conversation sort of three questions that we can ask ourselves. And I think the commission did this really nicely. Is what we're doing effective? Is it efficient? And how well is the process that we're using working for us? So are we doing things right? Are we doing the right things? And the environment in which we're actually in which we're doing all this. And I think the conversation here is really moving the yardsticks on all three of those points.
Denis?
Excuse me, very, very quickly, I would say that picking up on the organized crime theme, let's get organized. They're better organized than we are. So this is why I like the institutional reforms that are being proposed. I think it's absolutely crucial. And if you look at the whole compliance continuum, you need your regulators in there. Let's stop it at the beginning with regulation. There's a lot of information that can flow upwards, whether it's intelligence that can move from the regulators to investigators, law enforcement, etc. That's where it starts. So you need to reinforce the regulators, of course, intelligence and investigation unit. And so I guess that's my comment here is the commissioner has proposed a whole package, which I'm very happy with. I may not necessarily agree with his characterization of the effectiveness of FinTrack. I do have a lot of comments in that regard, but he made the best judgment with the information he had. I would have liked to have seen him have better metrics, better information, but that's the situation. Anyway, those are my comments with respect to the intelligence investigative unit.
Thanks so much. I'm going to move into some questions from the audience, but also keeping in mind that I did say that I would give you all an opportunity to make a comment and any other recommendations that you wanted to highlight or now's also your opportunity to highlight any recommendations that weren't made that you were disappointed in to not seeing. Jeff Simser has asked, the Proceeds of Crime, Money Laundering, Terrorist Financing Act is coming up for parliamentary review soon. Do the panelists have a view on how that review might benefit from the Cullen Report? So maybe just put up your hand if you've got an answer to that. Yeah, Denis, thank you.
Yeah, no, I think it can absolutely push the federal government to consider some of the recommendations. It has to. To ignore it would be, I think, a political mistake, particularly for the people of BC. I think they expect some movement, and they expect movement not just from the province, but also from the federal government. There was a list, and I mentioned this before, back in 2018, of at least about 18 gaps that needed to be covered in the legislation. And from what I could see, there's, I'll call it 1.5 that have been taken care of or will be taken care of. And there's a whole bunch there, including the luxury goods area. But there's so many that need. So I would hope that the next review and the next, probably the Department of Finance will put up another paper so that the committee that's going to be looking at this parliamentary committee and can work with that and identify some recommendations. But I certainly am happy to see the Cullen Report come at this time, because frankly, the federal government needs to pay attention and adopt most of those recommendations, at least the gaps fix the gaps and also fix their frequency of risk analysis. 7 years is way too long.
Yeah, I think the way the report is drafted, one of its huge contributions is actually trying to decipher what is a very complex space. And I think as a result of both the content of the report and the way the report is written, it makes a major contribution to, I think, helping people more wrap their head around this. Just my conversation with several members of parliament, there's now, I think, a real interest across all party lines here. That doesn't mean there's an interest by the government, but I think in a minority government situation, with the review and committee hearings, we might be able to make more progress than we would in a different circumstance. And it's not just the PCML TFA, so the act that's coming up for review. We also have the FATF country report that's coming due this year. And of course, the National Security and Intelligence Committee of Parliamentarians has been quietly for the last year working on a wholesale review of the federal policing responsibilities of the RCMP. We saw the Minister of Finance paying attention to FinTrack and FinTrack's remit in the aftermath of what transpired in Ottawa last February. A government that pretends to impose sanctions on Russia, but is only able to freeze assets in the hundreds of millions when a small country such as Belgium has been able to freeze 51 billion euros in Russian assets, I think suggests to us that perhaps there might be a gap to fill between some of the political intent and some of the political will and the ability to action that. And I'm hoping that at least some attention to FC3, the Financial Crime Coordination Center within the RCMP, that is still being stood up after years. But I think there are signs of hope here and growing interest, and hopefully we can maintain that interest.
I just thought I'd highlight in the comments. I had a comment both earlier on in this discussion, one comment that EFT transaction data was enormously helpful in investigations and tracing money moving transnationally. And I think that was accompanied by a comment that not enough people know how to read a FinTrack report and understand FinTrack information. I also had a contrasting comment that targeting upwards to work towards the source or head of the organization, a criminal organization, has little to do with data. Human intelligence was exploited in the past to work up cases that had local, provincial to national impact. Data rarely starts a case. Most are started through human work. So that's not necessarily exclusive in opposition to what was the other comment, but just two different perspectives there that I found very interesting to share. There's a couple specific questions. I apologize to attendees that I'm not going to pick up on for this audience, just because they're very particular questions about how FinTrack operates. And I guess my final question for the panel, and we're coming to the end of our discussion time, is simply, how do you keep up the political will to address money laundering? And maybe I'll start with Garry.
I try and do it all the time. I guess I've got I work with the media. I think there's some sound media out there that actually help us out. I'm doing a W5 story very shortly, and it sort of gets to some of what we're talking about today and really highlights it. Christian and Jeff and we've put a book together, which I understand Christian will be coming out of Queens very shortly, and talking about the whole money laundering. I've got my own book coming out. We've got to educate and put pressure on the politicians. And we got to use it. I mean, as Christian said, he spoke at a lot of panels. I think that's crucial that subject matter experts that are passionate about this need to be in front of parliamentarians. I've got a couple individuals I'm working with right now, and hopefully there's MP but called Chambers of the Conservative Party is really taking a keen interest in this. I'm hoping we can when I say use these people, I mean capitalize on their ability to be at Parliament and try and push this forward. I've been pushing the provincial government in Ontario, and I will continue to do that. That's if we can get some momentum and some of the politicians to buy into this, I then think it'll take a life of its own, and some of what we're talking about will be able to be accomplished.
Great. Denis, oh, I'm sorry. I might be. Maybe I'll ask our hosts. Are we able to get final comments from Denis and Christian? Do we have time for that? No one's telling me no. So Denis, go ahead.
Okay, no, certainly I agree with what Garry said. The media is particularly important. We need to make more of the public aware of the consequences of organized crime, its effects, corruption, the money that is transferred, brought into Canada for illicit purposes. It is absolutely astounding. I know that one province in particular criticized the estimate that was done by the expert panel in BC, and I thought, well, that was pretty interesting. You criticize people who are trying to estimate the size of the problem in BC, and also extrapolate in terms of what the gap is or what the money laundering scope is in Canada. Why don't you, in that particular province, do the same before you criticize other people for attempting to get a handle on the size of the problem? So I think the media can basically bring to the attention of the public the importance and of the problem, its impacts, as well as it affects the level of corruption in our provinces, in our municipalities, in government procurement. And it's very important that we work with the media to try and educate the public who should basically put pressure on politicians.
If you want to hold feet to the fire, this is the conversation to have. I think the best thing we can do is democratizing this conversation, because the biggest challenge we have is government lives in an echo chamber. The people they hear from, by and large, is their own agencies. And look, I have yet to find a testimony by the RCMP where the RCMP came before the government or came before a committee and said, oh, actually, we didn't do a really good job on this. So, this is not to single out the RCMP, but every agency will tell you that they're doing a fantastic job. And so let's actually have a more open and honest sort of conversations about our strengths and weaknesses. And let's move forward together among the many people who have an interest and the many stakeholders here. And let's start with our local communities that experience the harm and money laundering every day on their streets.
Great. Thank you so much, Denis, Garry, Christian. Thank you so much for your comments today. This has been a hugely interesting conversation for me, and I'm sure for all of the attendees. I just wanted to mention that you could find, audience members could find a recording of today's webinar on the Anti-Corruption Law Program LinkedIn page and the Center for Business Law website. And now we're going to have some closing comments from Carol Liao.
Thank you so much, Eileen. That was such an absolutely fantastic panel. Thank you, Eileen, Christian, Garry, Denis, for the informative discussion that gave us a lot to think about. It was a gold mine of expertise, and now your knowledge is out there and it's going to be available for the public to view and learn going forward, to which we're all so grateful. Money laundering, as we all know, is pernicious, highly adaptable and opportunistic, and the Cullen Commission had a vast mandate, although for some maybe not broad enough, and it's almost hard to wrap one's head around the different venues in which money laundering weaves itself. For all the lawyers on there, our ears perked up at the discussion on the panel had around the Law Society's oversight, and among other various ways. And the report, it was very revealing in the data it provided in its 1,800 pages and 101 recommendations, with the particular challenge being posed from the report in the implementation and ensuring effectiveness in those recommendations. That is why I especially love this panel as the perfect final installment in this critically important educational series the Anti-Corruption Law Program has offered up, to get to really examine those recommendations, the issues and challenges on how the AML commissioner would work, and the proposed money laundering intelligence and investigation unit, both aimed to bolster BC's capabilities, and the considerations of both the strategic and tactical sides of the space. So thank you to you for having such a high level quality discussion on a complex topic that was completely accessible to the public. You know, you gave attendees and listeners that may not be as familiar with the report so many perfect on-ramps to be able to deeply understand the context, the existing informational gaps in the report, and the live and relevant issues throughout your discussion. We're all so grateful for your time and for the fantastic questions that our very notable attendees today offered up in the Q&A. The anti-corruption law program has been on the cutting edge of this field of law for several years now, delivering free, public, and accessible knowledge and information, and a lot of behind-the-scenes coalition building. I very much want to recognize Norman Baldwin, John Ritchie, and my dear colleague, Professor Emeritus Joe Weiler, and all the contributors and incredible team behind the anti-corruption law program, which the Centre for Business Law is proud to support alongside Transparency International Canada and the Vancouver Anti-Corruption Institute. The ACLP really brings together so many experts and leaders in the field, and thank you again to our panelists today, especially for your contributions and helping conclude this important educational series. And as Eileen noted, a recording of this event is going to be posted online. These videos are free, publicly accessible, and has been the case in the past. There are often hundreds and sometimes thousands of post-event views. Norman, John, and Joe had the foresight, thankfully, in knowing this discussion on the Cullen Commission Report needed to be stretched beyond one session. It's an incredible collection of 4 important panels and is really serving as a platform for broader discussions beyond the series. So it's important for the public to be able to properly consider this dense report's recommendations and the issues involved in implementing these recommendations by our governing bodies. And as Joe mentioned, these conversations led by the ACLP, its collaborators and esteemed experts are having broader impacts across Canada and abroad. So thank you all for coming on behalf of the ACLP and the Centre for Business Law, Transparency International Canada, and the Vancouver Anti-Corruption Institute at iClear. If you want updates on upcoming events, please sign up for the ACLP newsletter, which is available online, has been posted in on the chat, and certainly sign up for the Centre for Business Law, TI Canada, and iClear mailing lists as well for future opportunities and events engaging in anti-corruption issues. We are grateful to you all for coming, for the very active Q&A, and for all the knowledge and wisdom that's been shared in these last 2 hours. So thank you again, and goodbye, everybody.